Now, you'll remember that on the 16th of April, Supreme Court judges in a case brought by the Group for Women Scotland ruled the terms woman and sex in the 2010 Equality Act refer to a biological woman and biological sex. Previously, the prevailing interpretation had been that a woman, for the purposes of the Act, was either a biological woman or a trans woman who is biologically male, yet has a GRC, that is a gender recognition certificate. This week, we'll be hearing different perspectives on that ruling and taking a much deeper look at how it could and should be interpreted on the ground. The Equality and Human Rights Commission has issued interim guidance, that was on the 26th of April, that in places open to the public, trans women, those people with GRCs and those without, should not use women's facilities such as toilets or changing rooms. We'll look at the practical dilemmas this ruling creates for organisations, businesses and individuals. Later this week, I'll be speaking to Sex Matters, one of the organisations who argued for this clarification in the law. But today, let's hear from a barrister who specialises in taking discrimination cases and who is also a trans woman and activist. That is Robin Moira White, who transitioned in 2011 and is co-author of A Practical Guide to Transgender Law. Good morning.
Good morning.
Welcome to the programme. So what are your reflections almost 4 weeks on from that Supreme Court ruling? Okay,
well, I don't think the ruling will survive a trip to the European Court of Human Rights in Strasbourg. There was a case called Goodwin back in 2002, and we didn't have the Gender Recognition Act out of the goodwill of some government. We had it because the European Court, under the convention that we wrote and we signed up to in 1951, told the UK that it had to have an effective method of acknowledging someone's change of gender. And whether or not, I think it's a particularly poor judgment by the Supreme Court. Whether it's right or wrong, what we have is a situation now where that recognition is not effective and will need to be corrected.
But on what grounds would the European Court of Human Rights potentially overrule the judgment?
Well, if you are a trans person, that acknowledgement of your changed gender has to allow you to live appropriately and with dignity. And if you go to the cinema or the supermarket and you are forced to use facilities that are not appropriate to your gender, then firstly, your rights to privacy are compromised and your right to live in dignity are compromised. I this week was talking about the circumstance of a trans woman who for 20 years has worked in a financial institution, is not known to be trans other than to her employers. And the employers are trying to decide whether they have to tell her to go and use the male facilities.
But could this not be a bedding down period in the sense of when organisations, businesses, workplaces begin to have also adjustments for those that are trans? Because with the Supreme Court ruling, it talked about for people not to be discriminated against.
Indeed it did. And there's been a somewhat unholy rush to exclude trans people from facilities, to take the Supreme Court's judgment to mean rather more than it does. And the Equality and Human Rights Commission's interim statement has been widely criticised by discrimination lawyers for being part of that unholy rush.
Why do you call it an unholy rush? What are you talking about?
Well, for example, access to spaces in workplaces is not determined by the Equality Act. It's determined by other legislation than that which the Supreme Court was looking at. And that a careful look needs to be taken at how people are to be accommodated with dignity in their working life and their daily life.
Which they may take steps to do in a way that they believe achieves that goal.
And I think it's put employers...
But I'm saying still following the Supreme Court ruling.
Well, perhaps not. Many employers or service providers have put out statements already that says we won't be excluding trans people from gender appropriate facilities because we don't think that's the right thing to do. And if we put ourselves in a position where business and service providers don't think that a ruling of our Supreme Court reflects justice and right and the dignity of people, Maybe that's why we signed up to a convention on that as long ago as 1951.
But do you not think, in an instance like that, for example, some of the examples you give there, that any person within that organisation has the right now to lodge a complaint with the EHRC and that with the Equality and Human Rights Commission that implements these laws, that took a look at the Equality Act 2010 in particular, and gave that guidance. An individual within those organisations now has the right to lodge a complaint if they disagree with that.
Well, they can lodge a complaint. What they've got to come up with is a disadvantage.
Which many people have, as we've seen in the run-up to this particular case.
Yeah, and it frankly puts employers and service providers in a nigh impossible position, because equally the trans person who's forced into facilities that they would say are not appropriate for them, or is forced to tell their work colleagues that they can't go and use the same facilities as them as they've been doing for many years, is equally put into an impossible position. The Equality and Human Rights Commission have a duty to uphold the convention rights of the individuals as well as the Equality Act rights. And so what this ruling has taken us into is a situation where I think you're likely to get complaints from either side of the debate.
With that, in relation, Victoria McLeod is a former High Court judge who is trans, told the BBC she will go to the European Court of Human Rights in Strasbourg to seek a declaration that the actions of the UK government and the Supreme Court violate her fundamental human rights, which I think is echoing a little of what you're saying there, Robin. And also, of course, we should say that the government has accepted this ruling, saying it brings clarity and confidence. And continue to say
the very last thing it does is bring clarity and confidence. It has brought muddle and doubt.
I think that is one perspective, and we're hearing a variety of them this week. But there are others that would agree with that characterisation of clarity and confidence. The Justice Secretary, Shabina Mahmood, she said, I think they've done their job, talking about the Supreme Court. I think they've sought to do it in a way that recognises that we're talking about a balance of rights, but sought to give confidence to a minority community that they still have protections. Why do you not believe that?
Well, at the end of the judgment, there's a long homily from the judges about trans people still have rights.
Mm-hmm. And that it shouldn't be considered a victory by either side.
Well, indeed. And I've heard words like vindication used by people on the gender critical side of the debate. The problem is that it's all very well having fundamental human rights, but if in your workplace you're forced to go, you very specifically rejected your birth gender, and now you're forced into facilities that reflect that, that is devastating for someone who has made those choices and made that difficult journey, and their rights are not being respected.
Why is it devastating?
Well, the definition, gender dysphoria, is complete unhappiness with your birth, sex, or gender, and people go through, as I'm sure is well known, considerable and difficult stages, which can involve the loss of family and friends, the loss of employment, having to seek new employment in different ways, having to seek medical intervention and surgery, and go through all that. And many of those people, in fact, the vast majority of those people, have lived perfectly successfully for many years in their affirmed gender. And to be now told that you have to out yourself to work colleagues and use facilities that you've specifically rejected is devastating.
I mean, there are people who would say it is devastating to have to share facilities, same-sex facilities, with a biological man.
And there are solutions to that problem, so that one of the areas that I practice in particular is religious discrimination, and some people from certain religions are very keen on the sex differences and maintaining the sex differences. And the way that you accommodate those needs are by providing additional privacy for those people who need additional privacy, not forcing particular groups into that additional privacy.
So if there were accommodations for additional privacy for trans people, Would that resolve the issue for you?
No, that's exactly the problem. You see, additional privacy for trans people. So you force the trans people into the additional privacy. If you say there are private facilities, and if you are disaffected by the idea that in your normal group there might be a trans person, then you can use the additional private facilities and know that you're not going to encounter anyone else.
But we do know with this ruling, the terms woman and sex in the 2010 Equality Act refer to, they say, a biological woman and biological sex. You will have also seen
does that mean, for example, that I have a barrister friend with relatively young children. So can she now not take her young male children into the female facilities when she's at the cinema or the beach or the supermarket? If she can, why are they allowed to be accommodated and not a trans person who transitioned 20 years ago?
And maybe it's boy, man. I don't have the answer on that one. But I do want to know from you, that's probably with their child under a certain age, but I don't have the specifics for you right now.
The Act is very clear. The Act says that boy and girl include, man and woman include boy and girl. That's what the Equality Act says.
When it comes to some people now describing you as a man, how do you react to that?
Those who do it are being deliberately offensive generally when they do.
Why do you say that's their motivation? They could say that they're identifying people by biological sex.
People can say all sorts of things. There are unpleasant ways to refer to all sorts of people. I never choose to use unpleasant ways to refer to other people. The choice of referring to someone in an unpleasant way is a choice.
They might say that having to be pleasant is not reason enough to use a term which they feel is biologically inaccurate.
Well, imagine I'm in a queue in a shop and I'm an out trans person. So people have seen me on the TV, have heard me here on the radio. And if the shop assistant happens to know who I am, all right, and asks perhaps another shop assistant to come and open another till and shouts across the shop, would you start with the man fifth down the queue? Would that be appropriate? Yeah, that's just plain unpleasantness. Now, if we're dealing with a court case where the gender identity of someone is relevant, that's a different matter. If we're dealing with how we behave to people in society, there are appropriate ways to refer to people and inappropriate ways.
Let me turn to the case again. According to the Equality and Human Rights Commission, or the EHRC, no trans organisations applied to be part of the case.
2 trans individuals, Vicky McLeod, the judge that you've mentioned already, and Stephen Whittle, Professor Stephen Whittle, applied to intervene. And they are eminence grises from the trans world. They were both involved in the drafting of the 2004 Act. There is no bar on individuals. It's relatively unusual that individuals intervene, it's more often organisations, but there is no bar on individuals intervening. And those individuals, to this day, don't know why they were not permitted to intervene.
But the Supreme Court, as you mentioned, it considers legal arguments, not lived experience. This is according to Acua Reindorf, one of the commissioners, said that thus an individual is never likely to get permission. How do you understand, though, no organisation instead of an individual applying to intervene? I mean, just to let our listeners know, the list of interveners of organisations they did hear from was Sex Matters, also Scottish Lesbians, the Lesbian Project and LGB Alliance, the Equality and Human Rights Commission and Amnesty International.
Well, Amnesty put some very strong trans-positive points which were not followed by the Supreme Court, and I think are likely to form some of the discussion when this matter gets to the European Court.
You're convinced it will?
Oh, undoubtedly. I know of a number of applications which are in preparation at the moment. Vicky McLeod has already said she's taking her position to the European Court of Human Rights. The first time a trans person is forced into inappropriate facilities in the NHS, for example, there's likely to be injunction applications. And the new guidance which the Equality and Human Rights Commission are going to produce before the summer is susceptible to judicial review. And on judicial review, the European Convention rights become relevant.
Until then, will you abide by the ruling?
I will continue to live my life in the way that I've been living it for a long time.
So that sounds like a no to me.
Service providers and those who provide workplaces don't have a duty to police facilities. And I've never yet been challenged on my use of facilities.
You previously called Sex Matters, Kemi Badenoch and Baroness Faulkner, who heads up the EHRC, evil on this topic. I mean, we've just spoken about unpleasant language. Do you still stand by that word?
Yeah, it was a strong word used at the time relative to a particular action. But my family were involved in the Battle of Cable Street in the 1930s. And I'm afraid to say excluding vulnerable minorities is a pretty unattractive position for any organisation to adopt.
But many would say using language like that just inflames the rhetoric and could also be considered hateful speech.
I agree. I perhaps might not have, with a bit more thought, might not have used that word on that occasion, but I used it on that occasion and I stand by it.
So you do stand by it?
Mm.
Thank you for coming in, barrister, trans woman and author of A Practical Guide to Transgender Law, Robin Moira White. More on this topic, as I mentioned, including on Wednesday when we'll speak to Sex Matters, one of the organisations that were heard in the Supreme Court case. And next week, Baroness Kishwer Faulkner of the Equality and Human Rights Commission will be here to explain how the Commission is consulting on changes to its guidance. If you want to get in touch, 84844.